Excellent. Good afternoon, everybody. I'm just going to give it a couple of seconds to allow further attendees to join, and then we can kick off. Excellent. It seems to have leveled out there, so let's start. Okay, my name's Jamie Watt. I'm a partner at Harper McLeod. I primarily work in the areas of technology, intellectual property, corporate, life sciences, and medical. There's a large part of my practice area which involves companies trading across borders, both in goods and services. So for my sins, I have fallen into the area of working in international trade. And hence why I'm probably the best person within our practice to speak to you today regarding the upcoming end of the transition period relating to the UK's exit from the European Union. Now, a bit of housekeeping before we kick off. If you want to ask a question, that is certainly very much encouraged. You all have the chat function, the Q&A function available to you on the platform. So if you can just pop your question into that and we will pick it up as we go along. We're going to give a run through some fairly broad areas today. Now, in relation to that, of course, there are going to be a lot of peculiarities in relation to certain areas of business which may not apply to other areas. Now, we're also very much an open door. So, I mean, if you have something very particular that you would like to discuss, or of course, if you're wanting to discuss something where there's issues of confidentiality and you're not happy or not comfortable about popping into the chat and running it through in the context of this seminar, absolutely do get in touch with us following the seminar. My contact details are at the end of the presentation documents that we've sent out. So I think that's probably all we have from a housekeeping point of view. And if we can move on to the first slide, Kira, that would be great. Excellent. Okay, so trading after Brexit. The first point I'm going to cover off is there is a health warning. What I'm going to say today relates to the possibility that we are going to fully leave the EU in transition without a deal having been put in place. Now, a lot of this, although not all of this, may be affected if we still get a deal in place. However, it is now the 19th of November. The end of the transition period is 31st December. Trade deals typically take often 2 to 3 years to get into place. We have been negotiating with the EU for quite a period of time already, but there still seems to be some major sticking points. On one hand, in relation to fisheries rights, although there was some gossip in the press over the last few days that there may be some movement on that between the UK and, in essence, the French, I think, who are sticking on that particular point. The other area relates to state aid, and I know that's a significant point for the UK government to be able to have more flexibility in funding and supporting domestic industry going forward. So if we can get through that point, we may still get a deal in place. If we get a deal in place, it may be a very loose deal, and there may be a number of particular areas which aren't covered. So it is worth going through the possibilities of what you would have to do if we don't get a deal in place. And remember, that's the starting point. You will have to do these things unless we get a deal in place to mean that you don't have to do these things. Now, the first point over and above that in relation to your own particular businesses or businesses that you work with. I can't underline the importance of diligence enough. You need to, on the one hand, look through how you're getting paid, and on the other hand, look through your customer engagement trails. How do they work? Where are the people that are relevant to that located? Where are your employees located? How do you staff up? How are you going to get money into your bank account, and from where does that come from? Because if you don't have customers, you can't get paid, and you don't have people to do the work, then you're going to have problems running your business, So it makes a lot of sense to draw down in a simple flow chart money, customers, and people, how the work is performed. And to work through those, and if you've got interactions with the EU, or if you've got interactions with third countries which are beyond the EU, the lack of a deal could potentially affect relationships with third countries which are non-EU, and we'll come on to why that's the case shortly, and to work through theirs. Identify pressure points, look for advice. If you're not clear on the advice that's out there and what you can find out, then ask questions, because it is going to be much more of a problem dealing with something where you can't get employee A back into the country, into the UK, after the pandemic's over, because they went home during the pandemic. You're going to have problems if you have perishable goods which are held up at customs. And you're going to have problems if you can't get cash into your business when you need to pay suppliers. So, all of this is worth working through in advance. And I appreciate, a lot of you may have done that already, but if you haven't, it's very, very worthwhile doing at this point in time. So if we come on to the next slide, Kira, that would be great. And we can start talking through trade in goods. So there is some very useful information already out there on the internet. I appreciate that it is written in a fairly complicated manner, and I appreciate that it is quite easy to become lost and bemused when you're going through it. This is stuff that we've worked in quite extensively over the course of the last year and a half to look at possibilities. So if you need a quick route through some of this, please do pick up with us. More than I said, more than happy to help. So the things that you will be wanting to look at, particularly if you're trading goods with the EU, are you going to need a local EU presence to allow you to continue to sell those goods in the EU? You may have been trading through a UK establishment historically, and because the UK has been a member of the EU, then due to the free movement of goods and the entitlements that you have under the EU treaty as an EU member, you've been able to supply and circulate those goods about the EU without having to have a local presence. Consequence number one, the UK stops ultimately being a member of the EU, and the transition period ends. You no longer have those rights to the free movement of goods. It may require a local presence to be established within the EU, depending on the type of good and depending on the area that you work in, to allow you to continue to trade. Now, good examples of those are potentially professional services, which we'll come on to in a second, but areas such as medical devices, potentially on the chemical side of things, potentially on eco products, but it's something which is worth working through. You're going to also have to have a look at tariffs and duties. When the UK becomes effectively a third country in relation to the EU, by bringing goods into the EU or taking goods from the EU, are you going to have to pay tariffs and duties on that? Is there going to be import and export VAT, which you're going to need to address? Now, If a deal is not put in place, then we will default onto WTO rules and a WTO schedule for the tariffs that you need to apply to the goods that you're moving across the borders between the UK and the EU. So it is worth working out what is going to apply and what additional cash flow issues are going to have to come out if you're moving goods in and out of the EU. So very, very useful to go through that. To find out what it's going to apply, I mean, there's some very useful search facilities provided by the government. You know the commodity codes relating to your goods. You pop those in and it can give you an idea of what tariffs are going to apply and what duties you're going to need to apply. Now, if you're moving or if you have been moving goods from the UK into the EU and then onto third countries, you might want to look at bonding arrangements and deferment arrangements. This essentially means where if you're popping goods into a bonded warehouse, you're only going to have to pay tariffs, duties, and import VAT when you move them out of that bonded warehouse into free circulation within the UK or the EU. If you're going to move them to a third country, bonding arrangements can also allow you to move goods about effectively between the UK, EU, and third countries without having to go through the rigmarole of dealing with tariffs and duties whenever you cross borders. Now, one other point to mention when you're looking to move goods across borders, which if you've been trading with the EU substantially over the past few years, you're not going to be used to. If you've been trading with third countries, then you probably will be used to this already. And that's what documentation are you going to need to be able to provide when things cross the border between the UK and the EU. A lot of that will relate to the origin of the goods, and that's both the origin of the inputs and the end products that have come out of manufacturing processes. So you're going to need to be clear on your supply chain and be ready to provide that documentation. It makes sense to go through and work out what you're going to do in that situation prior to the end of the year, because the last thing you want is goods becoming held up at customs. You're likely going to need an EORI number if you haven't got one already to enable and facilitate you dealing with customs. There may also be the issue of withholding taxes in relation to countries that you're trading with. Now, withholding taxes is arise where there's not a tax treaty in place to give you protections to allow you to receive payments for goods and services from countries, international countries that you trade with. If there's going to be a withholding tax, then there's going to be money deducted by the payee from what they're going to pay you before they pay you. And a lot of these arrangements, we try to include what we call gross-up clauses. Now, in your contract, it's very useful, therefore, to say, if there's a withholding tax requirement, then the payee will pay you such additional amount, so as you receive in your hand what you were going to receive if it were not for the withholding. Now, very useful to have in place as regards protections when you're trading internationally. Probably less of an issue with regard to the EU, but probably more of an issue with regard to third countries. And that's why we've got mention of treaty access on there. Now, treaties with third countries, non-EU countries, have historically and continue to provide a lot of protection against things like withholding taxes and to facilitate trade with third countries. Now, certain treaties are held at UK level, and certain treaties that the UK has benefited from are held at EU level. Now, come the end of the year, absent a trade deal that addresses this point, then the UK's access to those trade treaties is going to fall away. So, alongside or as part of working out your customer engagement and payment flows, Think about what countries you're trading with. Think about whether your payment flows are going to be affected by accessing or failing or being unable to access various treaties following the end of the year, because that could cause a significant hiccup in your payment processes and also in relation to some of your supply chains. So moving on from that, there are a few other areas that are worth. If you jump back a second, Kira, just I got a couple other points on goods. I know I confused you a little there. Apologies for that. You're going to need to also look at, on the documentation side of things, the labeling of goods. Now, there will be labeling changes going forward where you're using UK manufactured goods and you're selling them in the EU and vice versa. There is the CE mark, which many of you will be aware of. And the CE mark is generally going to be okay to use in relation to goods which are brought into the UK up until the end of 2021. Following the end of 2021, you're going to have to use the UK CE mark, which is the UK's own equivalent of the CE mark. So that is something which you're going to need to factor into your planning. Now, to gain CE marking or CA marking, as many of you will be aware, for certain products, you can self-certify. So, I mean, your burdens there are going to be fairly low. For other products, it will require notified body involvement, notified body certification. Now, for products which are coming into the UK from the EU, the UK is going to recognize those, so that is fine. However, going the other way, at this present point in time, and this is something which may change going forward if we get a deal in place, but at this present point in time without a deal, the EU won't recognize UK notified body certification. So you will need to think about that if you're selling goods into the EU which carried notified body certification CE marks. There has been some indication from the EU that they will allow the transfer of relevant documentation from a UK notified body to an EU notified body, but it is something which potentially you're going to have to go through. When you're bringing goods into the UK from the EU, there's also going to be potentially some requirement to deal with importer labeling. Now, the best example of what you're going to need to do here is if you've seen within Tesco or Sainsbury's where they have US goods, for example, that are for sale. If you go and look at those US goods, there tends to be a label stuck over the main label, which details who has imported those goods from outside the EU, outside the UK, into the UK, into the EU. Now, going forward, we're going to have to do that in relation to goods which have come in from the EU into the UK. The overlabeling with importer details doesn't need to be done in the form of a label at this point in time. It can be done with separate documentation, but that's only for a transitional period. At the end of that transitional period, you're going to have to start practically sticking labels on stuff that has come in from the EU, which is a bit of a pain, but it is something to flag at this point in time. Now, the last point I will mention on the trade in goods is that there has been a lot of equivalence in relation to standards between in relation to the UK's involvement in the EU. Now, going forward, where you're selling the same good both on EU and UK markets, you're going to need to make sure that it meets both UK legislation for sale in the UK, and it's going to need to meet requirements of EU legislation for sale in the EU. Now, at this point in time, because effectively we have been harmonized in these areas for a long period of time, the legislation is generally the same. So if you have an EU regulation, which governs the product standards that apply in the EU, that will have applied in the UK. So you're going to be meeting that at this point in time. If there's an EU directive which has been implemented in the UK in relation to product standards legislation, then it's generally going to be coherent at this point in time. However, going forward, there is a significant risk that the two fields of law will diverge. So the standards that will apply in the UK may very well be different from the standards that apply in the EU. So it's to keep an eye on that going forward. If we get a trade deal in place, there may be some equivalence there that comes from that, but I know from the commentary and from the comments of the government over the past year that a loosening of certain standards or a different approach to standards is something which is very much has been driving in the area behind this, I would add on top of this, there's some very useful guidance upon government websites, and there's some very useful guidance in relation to specific sectors upon the EU website. And if you need pointed towards that, please do let me know afterwards. Okay, if we can jump on briefly to services, Kira, now that would be great. Okay, so services have often been referred to over the last few months as the forgotten child of Brexit, because there has been an awful lot of talk in relation to cross-border trade in goods, and there has been very little mention in relation to the cross-border provision of services. Now, the biggest thing that you will need to do here is to find out if, going forward, you are or you require to be locally authorized within the EU in relation to the type of services that you provide. Now, big areas which red flags attached to at this point in time: financial services, taxation-related services, accountancy services, and professional services generally, legal services. I carry out a lot of trademark-related work, and that's another area where local authorization to allow us and you to keep doing what you do in the EU may need to be arranged. At the end of last year, I managed Hart McLeod's formation of a Dutch office to allow us to continue to carry out certain EU intellectual property work in front of the EU office. Now, a lot of our clients have EU trademarks, and that's something which we would not have been able to carry on if we had not set up a local EU presence to allow us to address that going forward, So it's key, if you're providing services, to check whether you need to be locally authorized to do that. And if you do, then you need to be thinking prior to the end of the year and absent a deal about setting up a local EU presence. There are other reasons for doing this in relation to data protection, and we will come on to those later in the webinar. We'll also come on to some of the practicalities about, well, you say you need an EU presence, how do you actually go ahead and deal with that? Another area you're going to need to think about is what's going to happen from a tax point of view and a VAT point of view particularly. There are certain simplification regimes which you will have had access to providing services across border, particularly one-stop shop in relation to digital services as an example, which we won't have access to if we don't get a deal, by the end of the year. Now, if you're wanting to access some of those simplification regimes, which have been really useful for certain businesses, you're potentially going to need to be in the EU to be able to do that. So that cascades back onto, whether you need to actually think about setting up a presence in the EU before the end of the year and absent a trade deal in place. The VAT that you historically charge may change. So I mean, there's a lot of mechanics here. So if you haven't spoken to your tax advisor, your accountant, in relation to those changes that are going to come in, it is worth doing that at this point in time. So particular areas to be concerned about: financial, as I said, tax, accountancy, professional, legal. Other areas where trade and services is likely to be affected and you're likely to have local requirements to deal with: healthcare, security, gambling, provision of temporary workers, and telecoms and broadcasting. So red flags for each of those areas. We'll touch on in more detail later on sanctions and controls, so I'll leave that to the side at this point in time. But again, I mean, this is something which will need to be considered generally. So if we jump on, Kira, to the next slide, that would be great. Okay, so one of the bigger and more complex areas which has been flagged by a lot of people for at least the last couple of years, which is going to be hugely affected by Brexit and is one of the drivers behind the UK leaving the EU, and that's access to personnel and employment. Many businesses have structured themselves so they use within their UK business staff whose nationality is one of the EU countries. Many companies use UK staff who have travelled abroad into the EU, to allow businesses to be furthered. Accessing talent is another area where people have come historically into the UK and particularly Scotland to train and to study, providing local businesses here with a ready access to a skilled workforce. And there are underlying benefits where the UK has enjoyed access to a level of European-wide health cover through the EHIC scheme and various social security benefits where people have worked and enjoyed the freedom to move about Europe in connection with their employment over the past 40 years or so, 45 years since we joined the EU. All of that is potentially going to end come the end of the year. You're going to need, if you have personnel that are coming into or you're wanting to bring in to your business from within the EU, you're going to need to look at the ability for you to get them in here to do work, and you're going to need to look at the ability for you to allow them, for them to remain within the EU, within the UK to conduct that work. Now, many of you will be already aware of the ability to acquire settled status for people that have already been working and living within the UK. So I'll not go into that in too much detail. Save to say, if you haven't applied or dealt with settled status and you haven't looked at your ability to remain where you're already living, it's something that you need to do very much at this point in time. Now, a quick aside in relation to study and training, it is potentially possible to bring people into the UK on a study visa. However, a lot of the short-term study programs which one might have been able to engage with historically are no longer going to be eligible, in relation to gaining a study visa. So there are minimum length requirements which apply to accessing or coming into the UK for study purposes. You're going to need to be able to demonstrate as well that you can speak English before you come into the country. There are certain countries which are pre-approved as regards an assumption that people coming from there can speak English. If the people that you're bringing in for study purposes are not from one of those countries, then you're going to need to look at a list of certain types of qualification which are sufficient to allow demonstration of the ability to speak the English language before they come into this particular country on a study visa. So that's some comments on the study side of things. The next main route to bring people in and much more applicable to businesses will be the skilled worker route. And this, in essence, replaces the Tier 2 visa route that has been in place for a number of years. The skilled worker route will open on 1st December to allow applications for people to come in as a skilled worker. To qualify for a skilled workers visa, you're going to need to have a demonstrable level of minimum level of skills, and there are certain salary thresholds which you won't be able to go below and still be able to come into the country as a skilled worker. The approach taken in relation to skilled worker access is a scoring approach. So you need to accumulate a certain level of points in relation to the evaluation of the role, the person, etc. And if you get enough points, you can come in. Some points may be tradable within organizations. Some points are not of that nature. If the skilled worker also relates to a certain specified shortage occupation, then it's potentially going to be easier to get them in that situation. It is important also to note that there will be provision for intercompany transfers in relation to high earners, which provide a greater degree of freedom to bring higher level management and higher paid workers from other parts of the world into the UK to work within UK business. If you're going to be bringing skilled workers in, if you're going to be bringing people in on study visas, if you're going to be bringing people in that aren't already there already, you're going to need to look at whether you have in place a sponsor license to allow you to do that. So you have to be a licensed sponsor to bring people in into your workplace on a visa, in essence. The other area that I will mention are frontier workers. Now, frontier workers are those who work within the EU, the EEA, or Switzerland. There's a special dispensation in relation to the Republic of Ireland at this point in time. Now, if you have somebody who's been in prior to, is working in the UK prior to and at the end of the year, then potentially they can gain leave to remain under the Frontiers Workers Scheme. Applications for that will be launched on 10th of December. However, if it's somebody that you're wanting to bring in as a frontier worker following the end of December, you're going to need to go back through the point scheme to be able to do this. Now, one particular concern that we've had here and we've seen coming up here in relation to a number of businesses relates to the pandemic and the ability of people working from home. So the issue is, if you have a worker from a frontier state and they're in essence working at this point in time for you, and they're going to be working at the end of the year, if they've gone home because of the pandemic to their home country, despite the fact that they're still working from you, they're not going to pre-qualify or retain their frontier worker status if, following the end of the pandemic, they look to come back in. So that is something which you may want to give some consideration to, and whether if you need to bring forward, prior to the end of the year, workers into your UK business physically to allow them to qualify for pre-approved frontier worker status at the end of the year, because If you don't, and you want to bring them in on 2nd of January, it's going to be back to a points and scoring issue, which is going to potentially cause you, at the very least, a lot more administrative hassle and potentially prevent you from moving those workers into the UK in accordance with your plans. So we have seen some clients moving forward some of their frontier worker staffing plans to allow them to gain benefit of this prior to the end of the year. So that's what I'll say on immigration at this point in time. On social security, this is an area which hasn't been addressed really at all by the government or the EU at this point in time, and there seems to be nothing agreed at this point in time. There is a risk. Therefore, if you have a worker who is working for a UK company but is out physically in the EU, that there may be double counting of social security contributions. That is something which is worth looking at this point in time, because ultimately it's going to affect what people take home in their pay packet, and if you're getting hit twice for effectively social security and national insurance contributions, it is going to impact upon that particular worker quite significantly. Health and insurance is the last point that I will touch on here. Now, as I mentioned earlier, we've all enjoyed the benefits of the EHIC card now when traveling within Europe over many, many years now. But unless we get something in place before the end of the year, that benefit is going to fall away. So if you have people traveling for business within Europe, then make sure that you've got proper health insurance cover in place, because you're going to lose potentially that underlying benefit of the European health insurance scheme that we had in place before. Okay, conscious of time a little bit, so if we can jump on here to the next slide, that would be great. One of my favorite areas, IP and data protection. So many of the businesses that you work with have enjoyed over the course of the last decades the benefits of European level trademarks, European level design rights, and European level patents. Also some protections in respect of copyright and the ability to access and register certain European domain names. Now, come the end of the year, the EU trademarks that you hold will cease to apply in relation to the UK. However, a corresponding right will automatically be given by the UK Intellectual Property Office for the trademarks that you currently hold at EU level. And the same position applies to EU level registered designs. So there's not too much you need to do there. If you're using a UK-based representative for your EU level rights, if they don't have an office in the EU, then they will no longer be able to be your representative. So that's something you may need to address. As I said earlier, we went through a fairly detailed process in setting up a Dutch office to give us protection in that respect if a deal wasn't put in place to allow us to continue to do that work going forward. So it's something worth considering depending who manages your trademarks or designs portfolio. There are some points in relation to demonstrating use of your trademarks, which potentially will have an impact going forward. Historically, people have been able to invalidate your trademarks if you haven't used them, put them to genuine use at an EU level within the EU for a period of 5 years before which they are challenged. Now, the issue there is that if you've only used them in the UK, historically that counts as genuine use for the purposes of EU demonstration. But beyond the end of the year, if you've not used them in other parts of the EU, that EU use may be no longer relevant. So it makes sense to to have a look at your use strategies in relation to your trademarks going forward, and to make sure that you've got some EU-related evidence there that could be used to protect you in the event that people seek to challenge your EU-level trademarks beyond the end of the year. Now, on patents, it's really simple, thankfully. One of the few things about patents which is really simple. The European patent is a beast which was created by a separate convention, separate from the EU treaty. So everything with respect to the European patents that your businesses hold or use will continue happily without any particular effect due to the end of the transition period. So nothing to worry about there. Copyright, again, the position will generally remain the same at this point in time. However, there is likely to be some divergence in the laws going forward. So it makes sense if you have a business which is built upon copyright as its key asset to maybe over the next 6 months conduct a strategic review of what you're doing in that area and see if there's anything which can be used to improve your enforcement strategy. On domain names, the biggest change there is many of you will have used a .eu domain name in relation to your business historically. As the UK will no longer be within the EU, you won't be able to hold that as an EU, as you're not an EU business. However, there is a way around that where you could use a trustee service to allow that registration to be maintained. Now, customs actions is an important area. For those of you who have used the very, very useful customs registration procedures for intellectual property rights, historically, where customs will take note of your IP rights and hold stuff up at borders, at European borders, to stop counterfeit goods coming in. If you have those in place, they're generally referred to as AFAs, come the 31st of December, for UK companies that hold an EU AFA, those AFAs will automatically terminate. You will need to have new customs actions put in place at that point in time, or prior to that point in time, to allow you to gain the continued protection of EU border force going forward. Now, to do that, you're going to need to have an EU IORI number, because your UK IORI number won't allow that. So if customs actions are an important part of your business, absolutely that's an area that you need to look at this point in time. Now, jumping briefly onto data protection, as many of you will know or understand, we have had for a number of years the GDPR. The GDPR was implemented in the UK through the Data Protection Act 2018, and it's all been fairly straightforward up until the end of the year. Now, at the end of the year, the UK is no longer part of the EU. There have been some benefits for countries which are not part of the EU, where their data protection laws have been deemed adequate, and that has allowed some flexibility in data transfers between those countries and the EU. At this point in time, the UK does not have an adequacy decision from the EU, and any adequacy decision in relation to the UK's data protection laws is unlikely to be through before the end of the year. So, if you're dealing in the EU citizen personal data and you're transferring personal data back and forward between the EU and the UK, it makes a huge amount of sense to look at the contractual controls that you have in place, the data sharing arrangements that you have in place, the data sharing agreements, in relation to that personal data that is being shared. Now, this is if you have followed best practice in relation to personal data historically and put in place decent data sharing agreements, there is probably not too much that you need to do in that situation. There may be a few tweaks that you require to the terms, but very useful. If you don't have decent and in-depth and best practice related data sharing agreements in place at this point in time, that's absolutely something that you need to address, because going forward, there is a risk, certainly, of breaching EU requirements and incurring fines as a result. One of the other areas that the GDPR addresses, which has been largely hasn't been mentioned terribly much in relation to a lot of the Brexit commentary, is one of the articles which states, if you are processing EU citizen personal data and you are not located in the EU, then you need to have an EU representative appointed. You need to have somebody who is physically within the EU to allow you to remain compliant with the GDPR in that respect. So if you don't have an EU base and you're processing EU citizen personal data from the UK, you're going to need to put in place an arrangement with an EU representative. Now, we have done this for clients, and we can provide that service if you need to, but it is something that you need to address. And it's something that you will need to address prior to the end of the year. The last point I will mention is in relation to contractual terms. And as I said, think about the contracts that you will have in place and think about whether you need to supplement those with data sharing agreements. Okay, jumping on to the next slide, Kira. That would be great. Thanks. So a couple of other points to sum up generally in relation to this. As I said, there is some disagreement between the UK and the EU in relation to state aid. If we don't get agreement there are still underlying regulations relating to subsidies which come through our membership of the World Trade Organization. So whilst some of the state aid controls that have their roots in EU regulation may no longer apply, there are still underlying state aid controls effectively under the subsidy regulations at the World Trade Organization. Now, I mentioned through a lot of this, if you need to set up a local office. This is certainly something that can be done. It can be done reasonably quickly, depending on which country you go into. If you're looking at somewhere like the Netherlands, factor in a few weeks to be able to do this. It's going to be longer, potentially in places like France or Spain or Italy. Different countries have different practicalities, different hoops that you have to jump through to allow you to set up a business there. Now, if you're setting it up as something which is purely going to be there to allow you to retain representative capacity or to be a letterbox in relation to contact within the EU, then you're going to need to think about who's going to be managing that business. Who's actually going to do the practicalities? Who's going to provide registered office services? Who's going to provide corporate governance support? So you need to think about through the actual practicalities of having and managing a vehicle that allows you to do what you need to do within the EU and allows you to tick the boxes required to allow you to continue to run your business generally. That potentially is going to move into the need for local legal advice. You're certainly going to need to get local tax advice and accountancy advice to make sure you meet filing requirements in that respect. So if this is something that you've worked out that you need to do but you haven't done yet, all in all, to have it addressed before the end of the year, you really need to be starting at this point in time to allow things to get put into place soon enough. This is unlikely to be something that you're going to be able to address if it turns out on the 23rd of December that we're not going to get a deal in place. So if you've got a feeling you may need to have a local presence, really do start thinking about that at this point in time if you haven't already addressed this. It makes sense to go through the commercial contracts that you have in your business. As I said earlier, right at the start, examine your customer and your engagement and your supply and your payment flows, and identify areas where performance may be difficult because you're dependent on something in the EU. Identify areas where you may get delays, for example, because you need to move stuff across borders. Identify stuff which could block you from doing certain things. And assess where you've got risk in the unknowns. It's a fairly quick process to go through, but an invaluable one to allow you to be able to respond in time where a threat or a risk is identified. Now, in connection with your contracts, you're also going to look at practicalities in relation to enforcement and what laws of contract apply, and be ready in that respect. If you have a business which has been dealing with a lot of debt recovery or this customer risk, depending on the sectors you're working in, it makes sense to look at how you're going to, and if your enforcement procedures are going to be affected by your exit, the UK's exit, or the end of the transition period for its exit from the EU. The last point I will flag, and this is maybe it's a point for any professional service advisor and also for their clients. Over the course of the last couple of years, reporting obligations in relation to transactions in businesses which have a cross-border element has increased significantly. Now, there has not been a lot of attention in the press over the past year in relation to something that we call DAC 6, and this deals with an obligation both on intermediaries like tax advisors, accountants, lawyers, but also businesses to report certain types of cross-border transactions to relevant taxation authorities. Now, there is a deadline coming up for transactions which contain certain types of hallmark, which have been implemented in the period which is effectively the last 6 months of 2020. The deadline for that is the end of January 2021. There's a second deadline which deals with reporting transactions which go back right to the start of 2018. So I don't propose to go into in any detail what it involves at this point in time, as it could really take a whole other seminar or 2 or 3 to do this. But if you've been involved in international transactions, if your tax advisor or your lawyer or your accountant hasn't mentioned DAC 6 to you, or you're not aware of it, it is worth, at this point in time, asking them, do I need to do anything about DAC 6? Because we have certainly found that the awareness on this level isn't where it should be at this point in time. And the failure to comply with tax reporting legislation can have significant consequence for your business, particularly if you deal with public sector contracts, government contracts, and things like that. So check your reporting requirements, particularly if you've never heard of DAC 6, it's worth asking about that at this point in time, because there could be something there that you need to do. One other point I will mention, just to add to everything there, which I didn't manage to include within the slide, as it's only come up in the last couple of days. There has been some draft legislation which has come out from the UK government which deals with restricted sectors and investment. We'll be putting out some material on our website on this fairly shortly to give you an idea of what that involves. But in essence, the approach will be that certain sectors are going to be specified by the UK government as crucial or important to the UK, and they are going to restrict or require approvals in relation to foreign investment in businesses, UK businesses in those sectors from abroad. So it is a new regime, not one that we have had for a significant period of time, but it's something which is worth keeping in mind to check off if you're looking for investment. That should fit into, as part of your general checks, also if you're looking at things like sanctions and restriction compliance from the point of view of international trade. So if you're looking for investment alongside, if you're going into any international commercial arrangement, make sure you run through your sanctions checks and you're not dealing with somebody that's on a restricted list. Very important, because if you don't, it can have criminal liability if you don't do that. It's a fairly simple thing to do, but it is worth reminding and picking up to do that if you haven't got into the habit of doing that at this point in time. Okay, that's basically it for today. So I don't think we've got any questions which have popped through yet. If anyone wants to ask a question, feel free to at this point in time. I appreciate it's been a fairly general overview of many areas which have particular and unique applicability to certain areas of business. But a lot of this, I mean, as I said, is off the top of our head stuff for us. So do feel free to pick up with us separately if you have a particular question. There has one which has come through, which is this verifiable CPD for the Law Society? Off the top of my head, I don't know the answer to that question, so we will come back to you, Kirsty, separately on that. I'll just need to check with our training manager as what boxes you need to tick for CPD. Okay, excellent. Well, thank you all for joining, and as I said, if you've got any other questions, feel free to fire them through. Brilliant, excellent.